To Save News TV. I am your host, AZ Hubbard, and today we're doing an update on the case of TD Jakes, which is a pastor, versus Duane Youngblood. We're going to read the case in order. First, we'll read the declaration from the attorney so that we will know how and who are the parties in this case. We'll also read the subsequent filings, which will be this request for discovery. In this particular declaration by Darrell Janey, she and the attorney for TD Jakes, and they are requesting a speedy expedite discovery process. So let's get into it. Darrell Janey, being duly sworn, states the following. I am an attorney admitted to practice in the state of New York and admitted pro hoc vice in the matter on November 27, 2024, and a partner of the Janey Law Firm, PC, attorney for plaintiff Thomas Dexter Jakes in the above captioned case. I submitted this declaration in support of plaintiff's motion for expedited discovery. On November 25th, 2024, plaintiff filed a complaint in the matter alleging that Duane Youngblood was liable for libel per se, and all defendants, including John Doe's 1 through 4, were liable for civil conspiracy to commit libel per se. Prior to insinuating this proceeding, on November 22nd, 2024, the undersigned contacted the Attorney Tyrone Blackburn, that delivered the letter labeled Appearance Letter, Preservation Notice, and Offer of Settlement, indicating that he represented Mr. Youngblood by telephone and left a voicemail to return the call. The call was never returned. Instead, despite my voicemail clearly stating that the undersigned represents Bishop T.D. Jakes, on November 25th, 2024, Attorney Blackburn contacted my client's business, i.e., his church, directly, speaking seeking to speak regarding the allegations. Once the complaint was filed by email dated November 25th, 2024, the undersigned contacted Attorney Blackburn again, this time to inquire whether he would accept service on behalf of Mr. Youngblood, whom we presume to be his client. In response, we were unceremoniously told the proverbial pound sand and to serve Mr. Youngblood. By December 4th, 2024, efforts to serve Mr. Youngblood had been unsuccessful. Accordingly, in an email exchange with Attorney Blackburn dated December 4th, 2024, we inquired as to whether Attorney Blackburn, on behalf of his client, had changed his position regarding the waiver of service. In response, once again, Attorney Blackburn refused to waive service, insisting that plaintiff serve Mr. Youngblood. Attorney Blackburn never stated whether he represents Mr. Youngblood for the purpose of this lawsuit. Subsequently, plaintiff was able to effectively service the defendant Youngblood on December 9th, 2024. The clerk of the court noted that the summons had been returned, executed by the plaintiff, and that defendant Youngblood was served late in the evening on December 4th, 2024. Defendant Youngblood's answer is due on December 26, 2024. At this point, no attorney has filed notice of appearance on behalf of Mr. Youngblood, and Mr. Youngblood explicitly rejected an offer to accept more time to respond to the complaint. I want you all to make a note of this part right here, because as we continue this series on Jakes versus Youngblood, this will come up again. Okay. In addition, I make this declaration to transmit to the court the form of draft rule 45 subpoenas plaintiff intends to serve. Exhibit A proposed draft form of Rule 45 subpoena addressed to podcaster known as Larry Reid, and Exhibit B, the proposed draft form of Rule 45 subpoena addressed to podcaster's company, Larry Reid Live LLC. Further, I make this declaration to transmit to the court true and correct transcripts of the podcasts relevant to plaintiff's motion to expedite discovery. True and correct copies of the following documents are attached. Exhibit C, 10/28/24, Larry Reid interviews Duane Youngblood, the abused become the abuser transcript. Exhibit D, 11/24/24, Larry Reid Live reviews and discuss Bishop T.D. Jakes' viral medical crisis video transcript. Exhibit E, 11/25/24, Larry Reid Live, Bishop T.D. Jakes goes after Duane Youngblood transcripts. Exhibit F, 11/3/2024, Part 2, Larry Reid interviews Duane Youngblood, the abused become the abuser, to the to be provided in a submission. I declare under penalty of perjury that the foregoing is true and correct. Okay. So that is what the attorney had to file. And now we're going to get into the filing itself. Okay, now let's get into the meat of this lawsuit. The plaintiff's brief in support of the motion for expedited discovery. The plaintiff, Thomas Dexter Jakes, thereafter plaintiff or Bishop Jakes, by and through his undersigned counsel, files this brief in support of the plaintiff's motion for expedited discovery. That is limited to two third party subpoenas seeking solely documents. A subpoena to be served on an individual that commands production of documents over a narrow time frame, and B, related a subpoena to be served on a aforesaid individual's business that also commands production of documents over a narrow time frame. Plaintiff anticipates that these two third party subpoenas would substantially reveal the identities of the John Does in this case, and thus enable this litigation to proceed more expeditiously and effectively. For the reasons set forth below, and in counsel's affidavit in support of the motion filed concurrently herewith, the court should grant the plaintiff's motion for expedited discovery. 1. Relevant factual and procedural background. On November 25th, 2024, plaintiff filed a complaint in the matter alleging that Duane Youngblood was liable for libel per se, complaint 50 through 65, and all defendants, including John Does 1 through 10, were liable for civil conspiracy to commit libel per se, complaint 66 through 71. Prior to instituting this proceeding, on November 22nd, 2024, counsel for the plaintiff contacted the attorney Tyrone Blackburn, that delivered a letter labeled as appearance letter, preservation notice, an offer of settlement, indicating that he represented Mr. Youngblood by telephone and left a voicemail to return the call. That call was never returned. Janie, Declaration 3. Once the complaint was filed by email dated November 25th, counsel contacted Attorney Blackburn to inquire whether he would accept service on behalf of his client. In response, we were unceremoniously told to proverbially pound sand and to serve Mr. Youngblood. By December 4th, 2024, efforts to serve Mr. Youngblood was unsuccessful. Accordingly, in an email exchange dated December 4th, 2024, with Attorney Blackburn, we inquired as to whether Mr. Blackburn had changed his position according to waiver of service. In response, again, Attorney Blackburn refused to waive service, insisting that plaintiff serve Mr. Youngblood. Attorney Blackburn never stated that he represented Mr. Youngblood for the purposes of this lawsuit. Subsequently, plaintiff was able to effectuate service on defendant Youngblood, and on December 9th, 2024, the clerk of the court noted that the summons had been returned, executed by the plaintiff, and that defendant Youngblood was served late in the evening on December 4th, 2024. Defendant Youngblood's answer is due on December 26th, 2024. At this point, no attorney has filed a notice of appearance on behalf of defendant Youngblood, and Mr. Youngblood explicitly rejected an offer to accept more time to respond to the complaint. Now, remember, we talked about that in the first filing from the attorney. So now they offered an extension, but now we find out that Mr. Youngblood has refused the offer for extended time. Again, keep that in mind because we will that will be revisited again. Plaintiff submits that based on the exchanges with Attorney Blackburn and that the absence of any notice of appearance in the litigation on behalf of defendant Youngblood, reasonably speaking, we do not have opposing counsel with whom we can confer on the subject of this motion, and we do not anticipate defendant Youngblood to provide information at this juncture. And we resolve that the subject of this motion, given the criminal background of defendant Youngblood and on information and belief and prior background of his co-conspirators, we submit that there is a very real danger that the information plaintiff seeks to identify John Doe's and provide a proper factual articulation in the amended complaint will not be preserved long enough to be available through the normal discovery processes. Here, plaintiff asserts a prima facie claim for conspiracy to commit defamation. Plaintiff alleges that the defendant Youngblood acted with others to publish and broadcast the false claims that Bishop Jakes groomed him and sexually assaulted Youngblood on a podcast reaching over 100,000 persons. Knowing that making such false claims on a podcast that reaches such a broad audience of listeners would harm Bishop Jakes. To wit, a person believed to be acting in concert with defendant Youngblood, that is, the podcaster identified in the complaint as co-conspirator number one, falsely claimed in sum and substance that Bishop Jakes had engaged in settlement discussions with Youngblood regarding his claim, thereby trying to give a patina of veracity to defendants Youngblood's accusations. No such settlement discussions ever took place. The first podcast occurred on October 28, 2024. In an effort to maximize their efforts, they launched a second broadcast on November 3rd, 2024, where they attempted to more clearly target the false claim of sexual assault against Bishop Jakes by, in sum and substance, stating that Bishop Jakes restrained defendant Youngblood and forcibly kissed him, as opposed to the first broadcast where defendant Youngblood alleges that they embraced at the end of an hour-long, wide-ranging conversation of faith and life and parents. Plaintiff alleges that the primary motivation for these acts is money. The defendants demanded $6 million, or in effect, the podcasts, two of which had already been produced, will continue. In yet a third podcast that aired mere hours after the complaint in this action was filed on November 25th, the podcaster admitted that he had seen at least one portion of the $6 million extortion letter sent to the plaintiff, and further admitted that he knew about the letter. 11/25/24. Moreover, the podcaster states that he knew the letter was being emailed to Bishop Jakes. 11/25/24. Larry Reid live. Bishop T.D. Jakes goes after Duane Youngblood at the 10-minute 43 mark. In another podcast, the podcaster concedes that he often pays interviewees on his show, and that to the extent they realize financial compensation for their grievances, to the podcaster expects to be compensated. Moreover, in the earlier November 3rd, 2024 podcast, the podcaster admits that he has knowledge of monies that might be paid to the defendant Youngblood as a result of his interviews. More particularly, during the November 3rd, 2024 podcast, Youngblood is asked by the guests whether anyone has reached out to him to pay him off. The podcaster interposes his own answers to the question by stating in sum and substance that he can answer that question for sure, responding in the positive. 11/3/2024, Larry Reid Live interviews Duane Youngblood. The abused become the abuser at the 1 hour, 52 minute, and 31 second mark. At this point, plaintiff submits that we have a reasonable basis to believe A, the podcaster has knowledge of defendant Youngblood's plan to obtain money by making false statements against plaintiff, including knowledge about the $6 million extortion letter sent to plaintiff. B, some financial compensation was provided to defendant Youngblood by the podcaster to participate in the podcast interviews where the false statements were launched. Further, on information and belief, plaintiff submits that there was a plan between and among defendant Youngblood and his co conspirators, including the podcaster, to share in the anticipated extortion payment once made. Moreover, the podcaster was able to realize other channels of financial gain by launching the series of podcasts related to defendant Youngblood's false statements against the plaintiff. The November 25th, 2024 podcast alone, by the podcaster's own admission on live show, attracted 5,607 viewers to the YouTube show. At the end of the show, the podcaster requested that 5,607 persons make a quote unquote donation to his show if they quote unquote enjoyed the update. A banner appeared on the screen advertising that such quote unquote donations could be made through a wide number of mechanisms, including PayPal, Venmo, and Zelle. The identity of John Doe's is essential to effectively advancing this matter. Without the requested early discovery described herein, plaintiff submits that he will be unreasonably delayed in amending the complaint to include the culpable parties. B, risks alternative conferences with the court once those parties are later added during traditional informal discoveries. C, suffers the burden, along with the other litigants, of potentially avoidable disjointed motions, initially challenging the complaint, which in turn will likely disrupt the orderly flow of the case management plan in this case. Here, the plaintiff knows the identity of the podcaster. Hereby, Bishop Jakes requires expedited discovery to further develop the factual matter to properly and appropriately support naming the podcaster and the company as named defendants in accordance with federal rules of civil procedure. Plaintiff anticipates that the requested information in connection with these two subpoenas will also reveal the identity of other John Does, whom will also be named as a result of the expedited discovery. Statement of questions involved. In consideration of the administration of justice and possible prejudice and harmful to the defendant, does good cause exist justifying expedited discovery by the plaintiff? Legal standard for expedited discovery. The plaintiff acknowledges that generally the federal rules of civil procedure, the FRCP, do not permit formal discovery before the required Rule 26F scheduling conference occurs. However, courts may permit expedited discovery before Rule 26F conference upon showing a good cause. Good cause may be found where the need let me get my place back, everybody. Good cause may be found where the need for expedited discovery in consideration of administration of justice outweighs the prejudice. Courts routinely allow early discovery where it subsequently contribute to moving the case forward and narrowly tailored for that purpose. Among other factors, courts consider: one, whether the preliminary injunction is pending; two, the breadth of the discovery request; three, the purpose of requesting the expedited discovery; 4, the burden of the defendant of compliance of the requested discovery. And 5, how far in advance of typical discovery process the request was made. And they note several cases here. Good cause is usually found where the plaintiff need the expedited discovery in consideration of administrative justice outweighs the possible prejudice or hardship of the defendant. Argument. Good cause exists in this instance. As the threshold matter, the plaintiff deserves a prompt adjudication of his claims against the defendants, which necessarily begin with the ability to identify the persons involved with defendant Youngblood in his efforts to systematically defame Bishop Jakes in exchange for the payoff and other related financial gains. Plaintiff has already mentioned the information that would support the factual articulation of at least one co-conspirator, but requires additional specific information that would support elaboration of the conspiracy claim, including the mechanics of the conspiratorial conduct, thus bringing to light an even clearer picture of the behavior at issue in this case and persons involved. This particular need supports the administration of justice in this case. Defendant Youngblood is not prejudiced by this expeditious discovery, and it does not impose any hardship upon him. This application does not deprive defendant Youngblood of opportunity to object to the intended Rule 45 subpoena because naturally he is able to articulate any opposition by responding to this motion. Moreover, the returns from the Rule 45 subpoenas would be made available to defendant Youngblood in normal course as required by the FRCP. Further, the Rule 45 subpoenas do not require any production from defendant Youngblood. So even if defendant Youngblood is per se, which means pro se, which means he's representing himself. In this action, the application does not request any material from him where he might otherwise be prejudiced in the absence of an attorney. The requests under the anticipated subpoenas are narrowly tailored. First, in terms of Rule 45, subpoena directed to the podcaster, the requests can be grouped analytically in the following manner. Requests 1 through 3, intended to establish actual identification, which is critical for properly identifying the punitive defendant. Requests 4 through 5, prohibitive of the relationship and interactions between the punitive defendant and defendant Blackburn over an anticipate approximately 3-month time frame encompassing a period slightly before the podcast and then the period during the two podcasts. Requests 6 through 8, information that would likely elaborate upon statements already made by the podcaster, including his knowledge about November 15th extortion letter and his interaction with Attorney Blackburn prior to the letter being sent to the plaintiff. Request 9, data and material that would augment plaintiff's current understanding about the punitive defendant's financial motivation to act in furtherance of and in accordance with defendant Youngblood false allegations against Bishop Jakes. Fundamentally, None of requests 1 through 3 can reasonably pose a burden to the punitive defendant. Proving your actual legal name and address is something most persons engage with every day across contexts. With respect to the remaining requests, the punitive defendant opened the proverbial quote unquote door on the inquiries at a minimum by and through his November 25th podcast that took place specifically in response to the filing of the lawsuit. Again, during that podcast, the punitive defendant, A, described having knowledge of the extortion letter, B, admitted to having at least some aspects of the letter, C, and strongly alluded to knowing that the extortion letter stated before it was sent to the plaintiffs. Most third party object to Rule 45 subpoenas because they do not want to be bothered with litigation that does not involve them. However, here, the punitive defendant specifically, intentionally, and deliberately imposed himself in matters of the lawsuit by his own provocative statements that raised substantive questions about his role and related legal liability as a participant in the conspiracy, all on the public broadcast and in the full face of and with understanding that lawsuits had been filed. The second Rule 45 subpoena on the company is similar in scope. The time frames for the request information are narrow. The requests largely mimic those in the first Rule 45 subpoena and are intended to avoid the situation where the podcaster claims not to have the requested documents, such as emails, texts, that otherwise maintained on a corporate device or system. We submit that the reasons for the subpoenas described above, on balance, favor the court granting the motion and permitting expedited discovery as described here. Again, the scope of the anticipated discovery is narrow. The purpose is clear. Efficient a process through the co-conspirators in this matter can be quickly identified and the complainant can be expeditiously amended so as to include those persons along with proper and appropriate description of their role in the conspiracy. Conclusion. For the foregoing reasons, the plaintiff respectfully requests that the motion be granted. Okay, everyone. We see now that this is their request for an expedited discovery, and they basically want the information from TD Jakes, want the information from Larry Reid Live and the Larry Reid Live show. Now, the question is, will Larry Reid be named as a John Doe number 1 or one of the John Does 1 through 10? We will see. Now, let's into the subpoenas. Now at the subpoena, this is Exhibit A. It's a lot. And this is filed in the United States District Court for the Western District of Pennsylvania. Thomas Dexter Jakes versus Duane Youngblood, John Does 1 through 10. And the publication you are commanded to produce at the time, date, and place set forth below the following documents, electronically stored information or objects, and to permit inspection, copying, testing, or sampling of the material. Okay. And it's signed on December 17th by the attorney Darrell Janae. Okay. Now let's get into the subpoena. The documents requested. Documents sufficient to identify your true name and legal name. Documents sufficient to identify your current and permanent address and telephone number. Your email address, all documents and communications referring to or relating to Duane Youngblood from August 1st, 2024 through November 25th, 2024 in your possession, custody, or control. All documents and communications referring to or relating to the transfer of any monies to Youngblood from August 1st, 2024 until and through November 25th, 2024. All documents and communications with attorney Tyrone Anthony Blackburn, Esquire, including but not limited to the settlement discussions referenced by you in the October 28th, 2024 Larry Reid episode titled 10/28/24, Larry Reid Live interviews Duane Youngblood. The abused become the abuser. Available on YouTube, Larry Reid Live show. All documents and communications with attorney Tyrone Blackburn, Esquire, referring to and relating to Anthony's Blackburn letter addressed to Bishop Thomas Dexter Jakes, dated November 15th, 2024. All documents and communications relating to Attorney Blackburn's letter addressed to Bishop T.D. Jakes, dated November 15th, 2024. All documents and communications referring or relating to views of the October 28th Larry Reid Live episode on November 3rd, 2024. Larry Reid Live episode titled 11/3/24. Part 2, Larry Reid Live interviews Duane Youngblood. The abused become the abuser. Documents sufficient to show the ownership structure of the Larry Reid Live show, Larry Reid Live LLC. So let's make this clear that this is the subpoena to Larry Reid. This is not to this is not to Youngblood. This is for Larry Reid to produce because they want to know the ownership of the company structure. Okay, documents sufficient to show all revenue derived from and or money collected by you in connection with the October 28th Larry Reid Live episode in and the November 3rd Larry Reid Live episode, respectively, including and not limited to payments or donations to you through your Patreon account, patreon.com, Larry Reid Live, and then it has the link. Definitions. Unless otherwise defined, all words and phrases used herein shall be according to their usual meaning and shall be interpreted in their common ordinary use. As such, in these requests, words and terms set forth below shall be defined as you and your refers to Larry Reid Live LLC and or any predecessors, entities, together with their affiliates, including but not limited to MBN network, subsidiaries, officers, directors, employees, agents, attorneys, representatives, or any other person currently or formerly acting or purporting to act on their behalf. Youngblood refers to Duane Youngblood, the defendant in Thomas Dexter Jakes versus Youngblood et al. 24 CV 1608, United States District Court of Western District of Pennsylvania, the complainant for which is attached. All shall be understood to encompass any and or shall be understood conjunctively and disjunctively as necessary to bring within scope of these requests all information, documents, things, or communications that might otherwise be construed to be outside their scope. Communications shall be construed in the broadest sense to include any oral and written transmitted information, facts, opinions, ideas, or thoughts between persons, including but not limited to by means of documents and including the transfer of data from one location to another by electronic or similar means. Communications include but not limited to dialogues, colleges, discussions, or conversations via telephone, video conference, or in-person meeting, text messages, instant or social media messages, emails, and calendar invitations. Referring or related to shall be construed in their broadest possible sense and include but not limited to referring to, reflecting, memorializing, comprising, constituting, containing, creating, bearing upon, identifying, supporting, showing, contradicting, defining. Okay, so we're not going to go through all of this because this is just basic definitions. Oh, so let's skip down to the instructions. And for those that are, let me say this, for those that are members of this channel, I will put this document, the links to this document inside a post for members only. This will not be put out to the general population, but if you want to become a member of the channel, you can simply by, subscribing, going down below and click the membership tab, and you can, be a member like that. But this is exclusively will be available to the members so they can read, if they wanted to, those things. Okay, instructions. In accordance to federal rules of Civil Procedure 45, you shall produce all the documents for inspection as they are kept in the usual course of business, and you shall organize and label them to correspond with categories of the following requests. Okay. So, pursuant to Federal Rule 45, you are required to produce all documents responsive to the request below that your possession, custody, and or control, including without limitations, information located in the files of any and all past or present directors, officers, agents, representatives, employees, attorneys, and accountants of or retained by you. Okay, so as I stated, this is pretty much um this is pretty much the definitions and instructions on what they are to produce. Again, the whole documents of these, the links shall be in the membership for our members. So let's get to Exhibit B. Yes, everybody, I know this is long, 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 but we got to get through it. We almost done. So this is Subpoena B, Exhibit B. This is the subpoena to produce, United States District Court of Western District of Pennsylvania, Thomas Dexter Jakes versus Duane Youngblood and the John Does 1 through 10. Subpoena to produce documents, information, or objects, or to permit inspection of premises in civil action. Production. You are commanded to produce at the time, date, and place set forth below, following the documents electronically, stored information or objects, and to permit inspection, copying, testing, or sampling of the material. Okay. Now, again, like I stated, it's signed by the attorney. This is Federal Rule 40 for Procedural 45. And like I stated before, I'm not going to read through this whole subpoena because it's a bunch of instructions and stuff. I'm going to read the pertinent part. If you're a member of this channel, you'll be able to get the links to this document in the post that I'm going to create regarding this. So, again, documents requested to Larry Reid Live. Now, documents sufficient to show the ownership structure of Larry Reid Live LLC, the registered agent of the entity, the mailing address, the physical address where Larry Reid Live podcasts published on YouTube broadcasts. All documents, communications referring to or relating to Duane Youngblood from August 1st, 2024 until and through November 25th, 2024 in your possessions. All documents, communications referring to or relating to the transfer of any monies to Youngblood from August 1st, 2024 until and through November 25th, 2024. All documents and communications referring or relating to the transfer of any monies to interviewees of podcasts hosted by Larry Reid Live over the past 36 months. Wow. 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 Okay. I'm gonna do a little commentary after I read this. A couple of things that I want to. That right here, over the last 3 years, that Larry Reid has to produce in this lawsuit. I mean, in the subpoena. Okay. Okay. All documents and communications with Attorney Anthony Blackburn, including Attorney Blackburn's letter addressed to Bishop Thomas Dexter Jakes, dated November 15th, 2024. Documents sufficient to show your calculations for views on October 18th, Larry Reid Live episode, and November 3rd, 2024, Larry Reid Live episode entitled 11/3/24 Part 2, Larry Reid Live interviews Duane Youngblood. The abused became the abuser, available at Larry Reid's Live YouTube channel. Herein, November 3rd, Larry Reid Live episode, respectively, including communications pertaining to those views across social media accounts, including Facebook, Instagram, TikTok, and LarryReidLive.com. Okay, I'm not going to go through the definitions like I stated and the instructions like I stated before. They are asking for quite a bit of Mm. Wow. Okay. They are asking for quite a bit of information. Like I stated, if you're a member to the channel, you will be able to review the entire document um, before. So let's get ready for this commentary. Well, everyone, we have read all of the documents regarding the expedited request for discovery from Bishop T.D. Jakes on Duane Youngblood and Larry Reid live. We will now, not in this video, but the next upcoming video, um, Youngblood has made an answer. So we'll do that video afterwards on another video. Like I said, the extended portion of the subpoenas, the links will be in the membership section on YouTube. So if you're a member on YouTube, you'll be able to view the entire subpoenas, subpoena A and subpoena B, exhibit A and B. But as a commentary note on this, I wanted to say that this is a very interesting case. I know a lot of people are putting a more personal spin on this, but here we're going to just basically read out the documents so you will know what is actually in them and what is being said. There are several things, and we might do just a straight commentary video at some time, um, just regarding the commentary. But it's very interesting that we have that they requested 36 months from Larry Reid live show um, of funds and information. I know that there's been a lot of commentary on his channel regarding Bishop Jakes. But one thing that was said in the um, lawsuit, so and also remember that a lawsuit is not facts. It's just, them making claims. That's with anybody. So nothing has been proven. But they stated that Larry Reid paid people to come on the show. I'm not a big follower of Larry Reid live show, but I do watch it from time to time. So I could be in error. You all put in the chat and let me know if you know or not. But I've never heard of him paying guests like with us. When we have guests on our show, we don't pay guests to be on our show for that very reason. Because when you pay guests, um, or receive payment, it can get really tricky if without disclosure. Now, if we were to have someone on our show that wanted to promote their product or whatever, we would definitely let you know that they are a paid guest. It's very important in this space, and I know a lot of YouTubers or whatever, they are basically, just YouTubers, and they're not into the art of the journalism. And you also saw that was a sticky issue with Reverend Al Sharpton and Kamala Harris and um whatever his I forget his name, and Kamala Harris. When you do an interview or something like that and you are requesting funds, that really need to be disclosed, because there's a certain level of expectation. That's why we don't generally do that. We don't do that. But if we were to take a payment, if somebody wanted to promote their product, we would definitely disclose that it is a paid advertisement. But again, I don't know the workings of his podcast or whatever, so it could be a thing. I just never heard it. So, But anyway, I find that part very interesting. Also, which when you'll see the next video, you will see some more interesting things, and I'll do some commenting on that at that time. I just want to give you a little teaser. But anyway, thank you everybody for allowing us into your homes. We appreciate you ever so much. And stay tuned. Join the channel. Make sure you like, share, and subscribe. Join the channel. Become a member because there are perks to it, like I said. And I appreciate you. It's been a long read for me. And you all have a very prosperous and blessed day. Bye.